Assalamualaikum and hello to my beloved Dr. Muhammad Nazi. I'm Muhammad Amiruddin bin Muhammad Kamaluddin with the matrix number AP210211. I am the group leader for group 111 and today we will be doing our presentation about the evolution of negligence law. So without further ado, let's get the ball rolling. Before we begin, this is our group members.
Okay, so let's start off with the introduction. Now, negligence is a concept that has existed throughout human history. Negligence is defined in the legal sense as the failure to take due care, which leads to injury to another person or their property. Negligence is also a legal concept that refers to the failure to exercise reasonable care, resulting in harm or damage to another individual or their property. It plays a significant role in various areas of law, including personal injury, medical malpractice, and business liability. Understanding the concept of negligence is crucial for individuals, professionals, and organizations alike to ensure they fulfill their duty of care and prevent unnecessary harm. So, in this discussion, we will explore the fundamental elements of negligence, its application in different fields, and recommendations to reduce negligence as a whole. So, that will be all for the introduction. I will pass the presentation to Aina. Thank you.
Thank you, Amiruddin. My name is Nur Aina Safia binti Razali with the matrix number of AP210052, and I'll be presenting on the literature review that consists of three categories. The first category is tort law. According to Hugh Davis and Tamlin, tort law refers to the field of law that deals with most civil lawsuits where it strives to recompense those who suffer harm because of the action of others, and which seeks to punish people who commit crimes. Next, according to Hayes, the objective of tort law is to right a wrong that has been done to a person and to protect from the action of others. The initial aim was to fully compensate victims of harm that could be shown. Next, according to W.P. Duff, the wide range of civil action fall under area of torts that consists of two important people: the plaintiff, the person that injured, and the one that is suing. The next one is the defendant, whereas the person who did wrong and are the one that being sued. Next one, on types of negligence. On the gross negligence, according to Weck's definition, it is considered as more harmful as it applies to a thoughtful disregard of consequences to the failure to avoid harming the life of other. According contract counsel, in the event of a breach of contract, a victim must demonstrate the other party's carelessness as to receive compensation. Next, on comparative negligence, according to Web Controller, the jury, judge, or insurance company will allocate a responsibility to both to the plaintiff and the defendant if both are contributed to the injury through negligence. According to Weck's definition, the plaintiff may seek damages for 1% of their responsibility under the states of pure comparative negligence law, even if they are at 99% at fault. Next one, on contributory negligence, according to Kagan, the plaintiff does not take reasonable precautions for their protection where it can prevent recovery of compensation awarded to a plaintiff. According to Weck's definition again, the level of plaintiff or defendant's respectively carelessness are irrelevant, but as for the benefits of all of nothing, as it spares the courts from having to precisely assess. Last one, on vicarious liability, according to Tim, any party in an authoritative legal connection with another party is legally accountable if their acts cause injury to other party. Next, clinical negligence experts said that the link between an employer and an employee will most frequently result in vicarious liability. On the last category, the elements of negligence, the first one is duty of care. According to Canton, making decisions that are morally, financially, and legally sound is must performed by a duty of care. The other positions in the financial sector are likewise subject to the duty of care, as the best interests of their clients are something that accountants and auditors are obligated to uphold. Next, on the breach of duty, according to Hasnell law, a person's behavior falls short of the applicable level of care. Next, on Johnson, it stated that establish a duty of care is foreseeability. This means that if a jury determines that the harm was foreseeable, the perpetrator was a negligent. Next, on causation, according to Winningham, the cause and effect link between an event or action and the outcome. As to prove the causation in a personal injury case, you must go beyond simply proving that the defendant was negligent. Lastly, on damages, according to Art Council, it is the court-ordered compensation for physical injury, property damage, and related expenses caused by another person's negligence. According to Staff, a person to whom defendant had a duty of care must suffer damages because of the defendant's failure to use reasonable care, and a personal injury claim must be filed in court within the necessary time limit. That's all from me. I'll pass to next presenter, Kairinisa, on the discussion part. Thank you.
Assalamualaikum. My name is Nurul Kairinisa binti Rosman and my matrix number is AP210153. So I will explain about the discussion part, which is starts with my part in type of negligence. So the first type is gross negligence. Gross negligence is the most serious sort of carelessness, and a finding of gross negligence can result in a higher number of damages. So gross negligence is a deliberate behavior that causes severe problems with other people's safety and health. This type of behavior is dangerous. So next is comparative negligence. Comparative negligence happens when numerous parties engage in an accident share some of the blame. So this negligence is divided into two approaches, which is pure comparative negligence and modified comparative negligence. Pure comparative negligence will only pay for what they were entitled for. As example, if they were found to be 60% guilt, they will only get the 40% of the compensation. So next is contributory negligence. So this negligence refers to the plaintiff's own carelessness conduct that contributed to their injury. It's an all or nothing attitude to culpability that can have significant consequences for personal injury victims. In comparative negligence, a plaintiff may still recover for damages if they were partially at fault, but in contributory negligence, any wrongdoing on plaintiff's side precludes compensation. And lastly is vicarious negligence. Vicarious negligence is also known as vicarious liability. Is another type of negligence that must be considered and analyzed before filing a claim to recover damages. This distinct type of negligence allows another person or company to be held liable for the action of another. Thank you. That's all for me.
Hi, Assalamualaikum. Next, I will explain the next discussion, which is elements of negligence. First, I would like to introduce myself. My name is Zarina Yudani binti Swandi. My matrix number AP210471. So there are 4 elements of negligence. First is duty of care. So duty of care is there are various circumstances in which someone may have acted carelessly. No claim will be made unless there is a duty of care owed the person who made damage because of the carelessness. Also, this duty of care is frequently viewed as control mechanism in the law. Second is the breach of duty of care. So when a person's behavior falls short of the appropriate level of care, there has been a breach of duty. This criterion is applicable whenever a professional renders a service to a person, such as when a doctor attends to a patient. For example, when a doctor scan ovarian cancer, but a patient have a breast cancer syndrome. So next is the causation. Causation is one of the most difficult parts in negligence, and also it is most significant. This causation divides into two, which is the first is actual cause. This actual cause more to straightforward. The second is the proximate cause is the official case of an injury. Last but not least is harm and damages. A person must demonstrate injury because of the other person's behavior to life. A negligence lawsuit. Negligence may result in bodily or emotional harm. Typical losses may include lost wages, property damage, and medical expenses. I think that's all from me. Thank you.
Assalamualaikum. Hi. My name is Muhammad Azir Irfan bin Muhammad Kiroda. Today I will present about recommendation. When someone is guilty of method willful negligence, they are aware that their act may damage others but choose to do them regardless. Someone is guilty of intentional carelessness if, despite knowing the risk, they regarded it and do nothing to mitigate it. Therefore, there are several to prevent such negligence. One of the most essential things you can do to prevent negligence is to adhere to all safety procedures and laws. Experts who have examined the hazard of a given activity or occupation create this process and laws. Safety glasses first. Eye protection. Eyewear protect against toxins, fly object and other hazards. Lift properly. Lifting heavy object improperly can cause back, neck and shoulder injuries. Lockout or take out prevents machine from starting during maintenance. This prevents serious injuries and deaths. Next is being aware of the inherent risk associated with heavy activity and tasks is crucial. Being aware of potential threats and adopting safeguards like training and protective gear is this. Working in a construction zone or a kitchen with hot stove and sharp blades required one to be aware of their surroundings and potential dangers. Lastly, to avoid get the right training in advance for any dangerous areas of activities. It should include risk avoidance information. Handling toxic chemical or operating machine requires proper safety training. Learn safe operation and danger awareness. This covers CPR, first aid and mechanical safety. This class teaches CPR and first aid. That's all for me. Thank you.
Assalamualaikum. Hello everyone. My name is Muhammad Yusri bin Shu'ib with matrix number AP210053. Now I will continue our group presentation with conclusion. So in conclusion, we can conclude that the problem with negligence is that term have a different meaning under law than it does in daily speech. According to Google English Dictionary, negligence is simply the inability to take due caution when performing a task. People are required to behave in a certain way in the eyes of the law. They must pay the affected party compensation if they fail to do so and someone is hurt as a result. The notion of negligence under the law is far more limited than it is in common usage. The reason for this is that the legal meaning is based on the idea of the reasonable person. There are four types of negligence, which is gross negligence, comparative negligence, contributory negligence, and vicarious negligence. Other than that, there are four elements of negligence which must be established for a claim of negligence to succeed, which is duty of care, breach of duty of care, causation, and harm and damages. That's all from us. Thank you.
That's all from us. Thank you so much for watching.